Your Honor, I'm here today to assert the constitutionality of the search conducted on the defendant, Jordan Bratton's computer on April 12, 2009. The evidence is constitutionally retrieved for the following reasons. One, Detective Malone accessed the site in the belief that it fell under the warrant, that he was researching.
Counsel, before you keep going, can you just lay out the law? What's the law on searches?
Oh, under Katz versus the United States, the court defined a search as a government intrusion into anything that a person has a considerable expectation of privacy for.
Okay.
Under this, in Bratton, the police obtained a search warrant looking for the murder weapon or anything related to the purchase of the murder weapon.
But wasn't the warrant in this case really vague? Didn't it pretty much say everything under the sea which could be searched?
No, it did not, Your Honor. It said that electronic objects such as CDs or right here, any electronic or magnetic form, such as any information on a storage disk, may be examined for evidence.
But doesn't the case of Chimera state that a warrant has to be specific to certain types of evidence?
That is true. However, Your Honor, a later case, U.S. versus directly contradicted it when it said that a warrant does not, or the evidence seized does not become invalid merely because items received outside of the warrant.
Well, then what's the point of a warrant? If you can go beyond the warrant and still use the evidence, what's the point of a warrant?
Warrants there to specifically guide the detectives in what exactly they're looking for. However, in this case, they were looking for something under the warrant. However, it also fell under the plain view doctrine because Detective Malone was happened upon Yellow, and it was an unfamiliar site, and under the plain view doctrine, the evidence he found was legally obtained because he just happened upon it, and its incriminating evidence was immediately apparent because it was a message from the President's home.
Once the judge starts, you stop. It sucks. But once they start talking, you stop. And they'll probably do that. But the plain view doctrine, can you explain that to me? What is that?
The plain view doctrine has 3 points. That an item is in plain view when police are legally in a position to obtain evidence. Its incriminating nature is immediately apparent, and that officers have lawful access to the warrant.
So in this case, when the officer sees the Yellow site, and I think he said he's unfamiliar with the site, how is the criminality immediately apparent?
He was unfamiliar with the site. He may have thought that it would have related to the murder weapon through the purchase, through the...
Well, how do you distinguish that set of facts from the case, maybe counsel can remind me of the name, where the police officer is walking through the house, sees a stereo that he thinks is, oh, that looks out of place, and checks it out. And I believe that search was considered unconstitutional and outside the plain view doctrine.
Your Honor, in that case, first of all, the police did not have a warrant.
But we're talking about plain view doctrine. That's no warrant. It doesn't matter about the warrant, right?
Yes, Your Honor. I just wanted to point out that case didn't even have a warrant. However, in that case, the police officer picked up the stereo, wrote it down, brought it back to the station, and he already had legal bias in his mind that he assumed that the stereo was out of place. It's absolutely different from the case of Bratton because the officer was merely, or the detective was merely examining the website, just maybe looking for clues to see maybe that's how Bratton accessed the murder weapon. And he happened upon a message from Preston Palmer, the murder victim.
But I understand that, counsel, but my question is, if plain view doctrine only applies when something is immediately criminal, or its criminality is immediately apparent. So if I see a stereo and it's clearly not immediately apparent that it's a crime, I can't search that. why did the police not in this situation, when they found the computer, go back and get an additional warrant that allowed them to search the entire computer?
Because Detective Malone was operating under the belief that he was searching for evidence relating to the purchase of the murder weapon. He thought that this electrical form, this laptop, would carry some sort of evidence as to how Bratton accessed the murder weapon.
So walk me through it. He sees the site, but assuming the warrant is no good, or the warrant, he's gone beyond it. He's opened the computer and he sees an unfamiliar website. How is that immediately apparent, the criminality of that? If it's not immediately apparent, then why can he look at the site?
Well, my main argument has been that he operated under the belief that he was looking for how Bratton had access to the murder weapon.
Why would he have a reason to believe that this site would lead to evidence of the murder weapon? Well, I think you can ask, remember we were talking about how on the front of the site he reads something that says this networks companies and people together, right? It brings businesses and companies together. Doesn't it say that on the yellow site?
Yes.
So I would, because I think you're going to get that question if the judge read it. So I'd say, well, Your Honor, when the officer pulled up the site, he saw that it said bringing people in business, whatever that line is, bringing people in business together. Now, you may be correct that even if we assume that this is not it's just a review site, he believed that this would lead to a place where people could buy products, and so he thought this would provide evidence, and that meant it was immediately apparent, and he could get into it.
Oh wait, so when I said that he operated under the belief that he would find it, I have to expand on that?
Right, I'm asking you to give the details why you believe that. You always want to go back to the facts, okay? Always try and go back to the facts and have the facts of this case specifically prove the law that you want to use. We'll move on. Think about that. Well, yes, please, proceed.
In Guest v. Lace, the court found that a search did not become invalid merely because items not covered by the warrant were seized. Therefore, in this case, just because certain reviews were seized, the whole search should not become invalid.
What about that string of pornography cases where people looked through computers and they found different pornography pictures, which are all immediately illegal, but that evidence was still excluded?
However, under those cases, the police officers could not use the plain view doctrine to justify further searches because the first images, in both those cases, police officers had no idea what the image title meant. In the subsequent files, they had an idea and they seized them anyway. They went above and beyond the warrant. However, in this case, in Bratton, Detective Malone was merely, like I said, operating under the belief that the website had connected Bratton to a possible murder weapon supplier. Therefore, that's how Bratton and those cases are different.
Well, does it matter what the officer's belief is?
Yes, it does, because they must have a legal justification for their search, which is...
Right, so let's say they don't have a legal justification, but the officer believes he does. Does that make the search okay?
Yes, it does.
Can you give me a case that does that?
In the case of U.S. versus Giberson, an agent discovered images of illegal pornography, but was still looking for